Hello, everyone. Thank you all for joining us today. This webinar, Emerging Frontiers in Mass Tort, Ethically Navigating GLP-1 and Depo Provera Litigation, is sponsored by Verus. I'll give everybody just a second here to funnel into the room and get logged in before we get started. CLE credit for this program is offered in California, Illinois, New Jersey, New York, Pennsylvania, and Texas. You'll receive the link to submit for CLE credit at the end of the webinar in the chat, and later today in a follow-up email with the presentation materials. There will be 3 CLE code words provided in the chat throughout today's presentation. Please make note of these code words for your CLE credit. If you're interested in requesting additional states, please email me to inquire about pricing. You can use the chat to submit any questions you may have throughout the presentation. We have time at the end to answer them. I'd like to introduce our moderator for today's discussion, Mark Evelyn, founder and chief strategy officer at Verus. Mark?
Thanks, Allison, and thanks to you and all your colleagues at Parent Conferences for organizing this today. Good afternoon, everyone. As Allison said, I'm Mark Evelyn, one of the founders of Verus LLC. And I've been involved in the administration of mass tort cases since the early 90s when I saw my first asbestos case file. I was about 12 years old at the time. I'm honored to serve as your moderator today and to be joined by 2 highly respected attorneys with deep experience in mass tort litigation. Many of you already know them, if not personally, then by reputation. Tracy Finken and Jonathan Oren. Tracy is a shareholder at the law firm Anna Paul Weiss in Philadelphia. I'm obligated here as a native Pennsylvania to insert a Go Birds. She's been handling pharmaceutical liability cases for the past 26 years, and most recently was appointed as the co-chair of the Plaintiffs' Executive Steering Committee in the Depo Provera MDL. Jonathan is an experienced pharmaceutical and medical device lawyer who's had a prominent role in asbestos and hernia mesh litigation, among many others. Jonathan is a partner at Motley Rice, and he is the plaintiff's co-lead of the GLP-1 MDL. Today's discussion will be covering a range of issues, including the litigation timeline, critical case management orders, science issues, litigation strategies affecting both plaintiffs and defendants involved in these cases. We'll be diving deep into certain emerging trends and key legal arguments that affect practitioners in this space. Jonathan and Tracy will start off by walking us through presentations, giving us an overview of both of these major MDLs, and then we'll make sure to leave plenty of time for discussion and Q&A from the audience. Thank you all again for joining us today, and let's get started. Jonathan, I'll hand the microphone over to you, and why don't you give us your update on the current state of the GLP-1 litigation?
Well, thank you so much, Mark. The one thing you didn't mention is that I'm a diehard Red Sox fan, but I will forgive you for not mentioning that. So thank you, everyone. I'm here to talk about GLP-1 RA litigation, or in MDL 3094. We all know these as Ozempic, Wegovy, Mounjaro, Zepbound, Rybelsus, but in my firm, we call it the Ozempic litigation because I think about 80% of the plaintiffs in suit are currently Ozempic cases. But we've got 2 defendants. We've got Novo Nordisk and Eli Lilly. And you can see the list of products that are primarily in suit here. There is some Trulicity and Victoza as well. The MDL itself is limited to gastrointestinal injuries. And I'll get back to that in a minute, but the courts, the JPML has held that that other claims that are not gastrointestinal in nature are not part of this MDL. And so there are some eye injury cases that are in New Jersey State Court and some in federal court in New Jersey that have just been filed. And I'm not really going to be focusing too much on those today. Although if you do have questions on the eye injury cases, please feel free to reach out to me directly afterwards. And I'm happy to share any information on those. But right now, there's no mass tort consolidation for those cases. So with regard to the gastrointestinal injuries, we're primarily talking about um, gastroparesis, which is paralysis of the stomach, cyclical vomiting, nausea, um, gallbladder disease, bowel obstruction and bowel perforation, ileus, necrotic conditions of the bowel, and necrotic conditions of the pancreas. So some pretty bad stuff. When I say gastroparesis and paralysis of the stomach, we see those plaintiffs typically having symptoms that go on for months and months, even months after cessation of the drug. And like I said, these often lead to multiple hospitalizations, inability to eat. The injuries do run the full gamut from being hospitalized for 1 or 2 days all the way to death cases. And so there really depends on a whole host of factors with each case. So as you can see from this timeline here, the MDL began in about January of 2024, a little over a year ago, when it was assigned to Judge Prater. The first status conference occurred in February, and Judge Prater unfortunately passed away last spring, and the case was ultimately transferred to Judge Karen Marston, who's now presiding over these cases in the Eastern District of Pennsylvania in Philadelphia. And promptly in May, actually, I should say, I guess it was in May, right before her appointment, that Judge Prater, the last act she did was appointment of plaintiff's leadership, where Paul Pennock, Parvin Amin Roya, Sarah Rueda, and myself were appointed co-leads over a pretty large steering committee. Over the first 6 months or so of the litigation, we were able to secure direct filing orders, plaintiff fact sheets, and a lot of the first day orders that you would expect in a litigation of this magnitude. In August of last year, the court set out and identified 3 cross-cutting issues, basically bifurcating the case, dealing with these 3 issues up front. And through the first part of this year, we engaged in the active litigation of issue 1. We're now in the midst of issues 2 and 3, and I'll talk about those in a second. So issue 1 has to do with the fact that about 80-something% of our clients in the litigation have this paralysis of the stomach, gastroparesis. And so one of the contentions made by the defendants in this case is that there is only one way to diagnose gastroparesis, and that is through a particularized test called a GES test. The defendant's argument essentially is that any plaintiff who has a clinical diagnosis has an invalid diagnosis and should not be able to pursue their case as a gastroparesis case. The argument essentially boils down to that if it's not gastroparesis, it's a constellation of symptoms, and that constellation of symptoms has been warned of. That's sort of where the defendants are going with this. So we argued issue 1. Issue number 2, and I'll get into more of that in a moment. Issue number 2 dealt with preemption and adequacy of the warning labels, and issue number 3 is general causation. And issues 2 and 3, as I mentioned a moment ago, we are in the midst of discovery on. We have started depositions. I took the first Novo Nordisk deposition last week. Tomorrow, we have the first Lilly deposition, along with the second Novo deposition. And this is also covering issues of general causation. We were limited in terms of discovery, specifically on marketing, but anything that's outside of issues 1, 2, and 3. So by order dated October 15th, the court really decided that it wanted to front load these early issues. So as I indicated back at the end of the year, we put forward some experts. Plaintiffs put forward Dr. Elliot Siegel and Dr. Daniel Rains. Defendants put forward Dr. Linda Nguyen. And the plaintiff's experts, Dr. Rains, who is a gastroenterologist, and Dr. Siegel, testified in turn, starting with Dr. Rains, that it is very common for a clinical diagnosis to be made for gastroparesis, in that the definition of gastroparesis is simply the delayed emptying of food with symptoms without evidence of some sort of obstruction. The Dr. Siegel, for his part, testified that a number of modalities can be used beyond a GES test if a doctor chooses to do so, but essentially it is part of the standard of care in his world to only do the GES test after a patient's already been diagnosed with gastroparesis, but to make further treatment decisions over the course of multiple years to repeat that test. Defendants, on the other hand, presented testimony from Dr. Linda Nguyen, who suggested that in order for you to call it gastroparesis, you have to have this particular test, though she does not do the test on patients who have had GLP-1 induced injuries. She prefers to call it GLP-1 induced delayed gastric emptying. So it's really just a matter of terminology, I think, and I think that plaintiffs provided more than sufficient evidence at the hearing, which was earlier last month, on this issue. We had a live Daubert hearing, and then a full day of oral argument. And I think the plaintiffs really proved our case in terms of issue one. So as I said, these issues 1 through 3 are ongoing. Briefing will occur over the course of the fall. So our discovery deadline ends in October for issues 2 and 3, expert reports, and then we anticipate to fully litigate this through the fall. Hopefully, we'll have full decisions on issues 1 through 3 in the early part of next year, and we'll be in a position to start picking bellwethers. I alluded earlier to the fact that there are other cases that are outside the MDL, in particular DVT cases, but also some other injuries, eye injury cases. Eye injury cases, there have been a number of studies that came out over the course of the last year, starting about January 3rd of 2024, showing a correlation with a particular condition of the eye that results in sudden blindness called NAION, non-arterial ischemic neuropathy, that causes sudden blindness. There have been now multiple studies over the course of the last year that have replicated that finding, and I think that there's broad consensus that there is a causal association at this point, and we just keep seeing more and more studies on a regular basis. Importantly, and sort of for the future, there was the first study that came out last week indicating that a form of macular degeneration may be associated with GLP-1 usage. So as we continue to focus on this litigation, I think it's important to understand that these drugs have not been on the market for very long, and that there are constantly new side effects that are being seen. And the truth is really 180 degrees opposite the view that the companies want to put forward, that is, that these drugs are very safe, that they're very effective, and that they're miracle drugs. When, just to give you some facts, about 80% of people are not able to tolerate the dosage that's fully recommended, so they have to take a reduced dose. People who are on these drugs tend to stop about 55% in the first year, about 75% by year 2. And the total weight loss in the real world is only about 3.6% on average, which is far less than the percentages advertised and seen in the clinical trials. So the real world experience is a far cry from what the clinicals and the vast advertising infrastructure show, when the reality is that the true safety and effectiveness of these drugs really should be questioned more. Look forward to answering some questions, but for now, I will turn it over to Tracy. Tracy?
Thanks, Jonathan. And I'm going to have to direct you to go through the slides. since I can't control the screen. But my name is Tracy Finken. I'm a shareholder at Anna Paul Weiss. And as I was introduced, I was appointed as co-chair of the Plaintiffs Executive Committee in the Depo Provera MDL. If you can go to the next slide, Jonathan. He's my trial tech today. Thank you. Okay, so the Depo Provera MDL involves Depo Provera, which is a form of contraception. It's been on the market for a very, very long time. It was first approved by the FDA in 1992. And it is an intramuscular injectable contraceptive. It was the only kind of injectable contraceptive that was on the market for a very long period of time. It was manufactured by Pfizer and went generic in 2004. After that time in 2004, Pfizer had authorized generics who were distributing the Pfizer product on Pfizer's behalf, and those manufacturers are Greenstone and Prasco. And we have found that the authorized generics have covered approximately 80% of the market share from post 2004 when the drug went generic. So those are essentially Pfizer products that were on the market post 2004. There are some regular generics as well, but the vast majority of use was by the authorized generics during that time frame. The injuries involved in this MDL are meningiomas, which are brain tumors. They're a form of benign brain tumors. They're very slow growing tumors that typically are not diagnosed until they become symptomatic, when they create pressure in the brain, and they can cause visual disturbances, balance issues, stroke-like symptoms, seizures, things of that nature. And that's typically when these women are diagnosed with these meningiomas. And while those brain tumors are benign, they have very serious consequences because of how big that they grow, and they cause a lot of issues with like neurotypical issues with these individuals, where they have significant long-term consequences. Typically, they have to be removed via surgery called a craniotomy, and that surgery, they remove a portion of the skull, take that off, and they remove the tumor, and then they replace the skull. It's a significant and serious surgery, and a lot of times these women have long-term issues related to the surgery or related to the meningioma themselves, and they can grow back as well. If you can go to the next slide. So this particular MDL it's been fast and furious right out of the gate. It was in January, February of 2025, it was assigned to Judge Casey Rogers in the Northern District of Florida. In March of 2025, Judge Rogers appointed plaintiff's leadership, and she announced a plan at the very first case management conference that she was going to fast track certain issues. She selected 5, what she refers to as pilot cases at the first case management conference. And through those 5 pilot cases, Judge Rogers said that she intends to basically deal with all of the cross-cutting issues that are at play in this litigation through those pilot cases. So she set a very aggressive schedule that discovery on preemption issues will be done in 120 days. We have been in the thick of it. The first depositions are starting next week. There have been a ton of documents produced, and the hearings on the preemption issues have been scheduled for late September. So we anticipate having a ruling on preemption by the end of the year. The other thing that Judge Rogers put in place at the very first case management conference is that she would like cases that are filed to do threshold proofs within 120 days of filing. And what that means is there is a very short 2-page questionnaire that has to be completed by the plaintiffs. And you have to provide proof of injury and proof of use. And this doesn't have to be exhaustive records. It just needs to be something. She said specifically that these records should not be more than 5 pages. So we're not looking for exhaustive records, but just threshold proofs that she would like in place 120 days after filing. And then there's also a schedule in place to deal with general causation expert reports and Daubert hearings. And those are all due towards the end of the year, with depositions concluding in the beginning of January, briefing, and will be in early 2026. And we anticipate having a decision on general causation in the first half of 2026. So things are moving very, very quickly. All of these cross-cutting issues should be dealt with within a year of the MDL being formed, which is really great for all of us on both sides. If you can go to the next slide, please. So as I had said, fast and furious litigation, there were 18 case management orders or pretrial orders that were issued by Judge Rogers between February 7th, 2025 and March 16th of 2025. And since then, there have been dozens more. So we are really, off to a great start. For anybody who needs to access these orders, the court does have a website, and all of the orders are available on the website. You can pull them up and look at them. I would advise anybody who's going to file a case to familiarize yourself with these PTOs, because there are certain things that need to be done in a certain period of time. If you can go to the next slide, please. So the notable orders that you really want to pay attention to if you're going to file a case in the MDL, there's a direct filing order in place, so you can file them directly there. There's pro hoc requirements that need to be undertaken, which you need to follow the precise instructions in the order. There's service through MDL centrality, which is really great for us. It makes it very, very easy to file your cases. And then PTO 17, as I had indicated before, deals with the threshold proof of use and injury requirements. So these are orders that you should really pay attention to, familiarize yourself with, so that you are ready to go and you don't have any types of issues when you get your case on file in the MDL. If you can go to the next slide, please. So as I said, with the threshold proof of use, this is portions of the questionnaire. It's very, very short. One thing that is an issue in this case is because the product has been on the market for so long. Like I said, it was approved in 1992, so it's been around for a long time. And it's not a product that was really provided through pharmacy. So you're not going to be able to request pharmacy records in the vast majority of cases to show proof of use. This is something that was delivered in the doctor's office, and a lot of times you have to get the doctor's records. They typically track them similar to vaccines, and you can also obtain insurance records, and sometimes you can find them in there. So finding proof of use can be challenging in cases where the use was a long time ago. And we've had mixed success with finding proof of use. As far as affidavits of use go, that has not been addressed at this point in time. It's under discussion. But to be able to do that at some point in time, you need to show that you did your due diligence and you've requested all of these records. So the questionnaire asks, have you requested prescription records, medical records, insurance records, pharmacy records? You need to check the boxes to show that you've done your due diligence to try to locate these records before you would be able to submit an affidavit of use. And like I said, that is still under discussion, whether that's going to be permitted or not. If you can go to the next slide, please. As I said previously, there is a direct filing order in place. It's PTO number 10. There are some specific requirements in PTO number 10 about the directly filed complaint. There's not a short form complaint in this case, but there are templates that are available. And if you need them, you can certainly reach out to myself or leadership in the case, and we can share them with you. But there are certain things that need to be in the complaint. And for example, if you're going to directly file it, you need to put the designated forum where it would be if it was not directly filed. That has to be in the case caption. And there are some other requirements. So please familiarize yourself with PTO number 10 if you're going to file a case directly in the MDL. If you can go to the next slide, please. And this is the plaintiff questionnaire as it relates to proof of injury. Very short, very succinct. And like I said, they do not want full records uploaded to meet these threshold proofs. No more than 5 pages. It's just something to show that they have been diagnosed with a meningioma. You don't need full treatment records or surgical records. It's literally a record showing diagnosis. And I should say that this MDL is limited to brain meningiomas. Spinal meningiomas, which are a thing, are not included in the MDL. So if you file a complaint that's alleging just a spinal meningioma, it's going to get flagged as deficient by Brown-Greer through MDL centrality right out of the gate. And those cases are not included in this MDL. It is limited to brain meningiomas. Now, there are cases where clients have both, and those cases are included in the MDL, of course. If you can go to the next slide, please. So as I said, there are pilot cases that have been selected by the judge. There are 5 of them. The defendants in those cases range. Some of them used authorized generic, some of them just used brand name product. And there are some specific deadlines for those particular cases. The general causation expert reports and the Daubert rulings will be geared through those 5 pilot cases. And so those scheduling orders are specific to these 5 cases. One of them is mine. And in my particular case, it is a client who used the product early on in the late 90s, early 2000s. And luckily, this is a case where we were able to find proof of her injections being given in the office. And we have significant proof of use in that case, despite it being early on. So, and she was diagnosed with a meningioma many years later. Can you go to the next slide, please? So some of the obstacles in the case, and I've touched on them already, and I'll move on so that we can, go get into some of the questions, but preemption is obviously a big issue in this case. This is what defense are hanging their hat on. They have been discussing this since the very beginning, the very first case management conference with the judge, and in their papers to the court, they intend to be, this is going to be their big defense, is preemption. With that being said, and that's why it's being teed up very early in the case, we do believe that we have a strong case to overcome the preemption defense, and we're looking forward to that. Like I said, the hearing has been scheduled for September 29th, and we anticipate that we will have a ruling hopefully by the end of the year. General causation discovery, we were given 180 days for that, so that is fast and furious as well. Expert reports are due later in the year. And expert depositions, I think, have to be done by January 10th with a briefing and a hearing thereafter. So we should have a ruling on that by this time next year, is my guess. There will be issues with specific causation, depending on the case. Obviously, proof of use is a hurdle that people will have to overcome. There are other types of conditions that can contribute to developing meningioma. So some of them, the more progesterone that you're exposed to, the higher the risk of meningioma, as well as there's a condition called neurofibromatosis, which can also cause these meningiomas. So these are certain things to be on the lookout for. Another issue that we might see in terms of the case-specific context is the statutes of repose, because the product has been on the market for so long. It's a very, very old product. So that's something that we're going to encounter when it comes down to the individual case-specific issues. And you can go to the next slide, please. Thank you. So as I said, this litigation is off and running. We think it's a very, very strong case. The science is very strong in this case. There have been multiple studies that have been published over the course of the past 3 or 4 years that show a significantly increased risk of meningioma for people who used Depo Provera for more than 1 year. 1 year is equivalent to 4 shots, because this is an intramuscular contraceptive injection. It was given every 3 months. So 4 shots has shown a highly statistically significant increased risk of developing a meningioma. There have been multiple studies that show dose response. So the longer you take the medication, the higher your risk goes to develop a meningioma. And with that, I guess we will move on to discussion with the panel.
Thanks, Tracy.
Oh, thanks.
Trying to turn my camera back on here.
There you
All
go.
right. Thanks, Tracy. Thanks, Jonathan. Both excellent presentations. I prepared some questions in advance. We may not get through all of them, and others may occur to me as we discuss these things. But I want to start off with since I've been involved in mass torts for a while, I have from the earliest days been involved in estimating liabilities around these cases. So I come at this with questions about the quantitative aspects, how many cases there may be, and based on what we know about the exposed population and the risk of these injuries arising amongst that at-risk population. So one thing that was not in the overviews you gave is just how big do you think these MDLs may become over time?
So as far as Depo Provera goes, at the first case management conference, we had this discussion with the judge, and it was estimated that there would be somewhere between 5,000 and 10,000 cases filed in the MDL. That number can grow. It's hard to say at this point in time. So there are currently about 500 cases on file. I think that the reason for that is because people are gathering their proofs, since you need to do threshold proof of use and proof of injury shortly after filing within 120 days. I think people are really taking the time to vet their cases and make sure they have their ducks in a row before they file. I know that's what we're doing. But I do anticipate that we will see probably close to 10,000 cases once it's all said and done. Now, the issue on whether this is ongoing, meningiomas have a long latency, which, we're still trying to nail that down, but it's a very slow growing tumor. So you can be exposed to the drug years ago and still be at risk of developing these tumors, into the future, and they're not going to be diagnosed unless you get an MRI. And this is not a routine test, obviously. So, people aren't really getting the MRIs and getting diagnosed until they become symptomatic, which means the tumor has to reach a certain size where it creates pressure and causes all types of issues. So, moving forward, I don't know what we will see in the future. We know that this drug has been used by over 74 million women worldwide. And I anticipate that, because of the studies that I discussed briefly earlier, the risk is significant. It's statistically significant odds ratio in the first study that came to light, the Roland study of 5.62, that's really high. So I anticipate that we're going to see people continue to be diagnosed as, their tumors grow and they become symptomatic, or maybe people go and get a screening MRI once they hear of the litigation. And we'll see where it kind of plays out.
Sorry.
Go ahead, John.
I was going to say, as far as the GLP-1 cases go, I've heard others guess, the same number, 5,000 to 10,000. And, I think that's probably a reasonable estimate as well. There are currently 2,000 or so cases filed in the MDL. I think a lot of folks are waiting for a short form complaint. The court is going to be entering an order at some point that the parties have proposed with a short form complaint. So I would imagine folks are waiting for that. But the sheer amount of usage tells us that there have got to be lots and lots and lots of people who are injured and or going to be injured. About 10 to 12% of the U.S. adult population has taken a GLP-1 drug or is on a GLP-1 drug, which is just a tremendously large number. You look at the rates of complications, and the numbers just add up. So I would probably guess that same range that Depo Provera is going to fall into.
So there are likely some differences here between these two MDLs, given the nature of the injuries and what the science tells us about the latency. Tracy, do you have anything that would indicate how long that latency period is between the Depo Provera usage and when these meningiomas may be diagnosed?
I think the science is still developing to some degree, but we've seen, I can say anecdotally within our cases, that we've seen people who've developed a meningioma, 15 years after using it. We've seen them develop it within 3 years after using it. So it's a wide range. But traditionally, a meningioma is a very slow growing tumor. So while they might have it for much longer until they're diagnosed, and they have to be typically become symptomatic to get diagnosed. So it's not something that, you're going to see. It's not going to be an acute reaction like you might see with GLP-1s, where you're taking it and you develop an acute event. You're not going to see that with the Depo-Provera cases.
Yeah, that seems to be one of the major differences here in terms of the onset of these conditions. Jonathan, and GLP-1, do these conditions linger after people stop using them? They arise fairly quickly, but once you stop using the drug, are there follow-on, knock-on complications?
So some of the complications are certainly permanent, right? You have starting with the eye injury cases, that is sudden irreversible blindness. Obviously, that lasts forever. The gastrointestinal injuries, we're uncertain at this point whether or not the gastroparesis is permanent or whether it is temporary. We know that for some universe of people, the majority do get better after some time, and that's usually out as up to half a year or more for an individual's intestinal tract to right itself entirely. For others, that never gets better. Individuals who suffer from necrotizing pancreatitis, who need pancreatic surgery, or individuals who have bowel conditions that require multiple bowel surgeries or intestinal surgeries, those folks have permanent, long-lasting injuries. So it really depends on the nature of the injury, but I think as you and Tracy observed, these are the injuries that occur while people are on these drugs. To the extent there may or may not be any latent injuries, we just don't know because there isn't a population of people that have been on them long enough at this point for there to be a body of evidence that says, there's a potential for cancer or whatever endpoint. We do know that it is at least linked to thyroid cancer or certain types of thyroid cancer, and there's a black box warning on them for that type of thyroid cancer. But what the future shows, we don't know at this point.
Both cases involve some element of generics, right? Other defendants selling Depo-Provera generics, and in the case of GLP-1s, you see a lot of advertising from the big compounding pharmacies like Hims and Roe. Do those complicate the litigation in any significant degree? Any particular issues involved with a case involving generic usage in Depo-Provera or pursuit of the compounding pharmacies and the GLP-1s?
So I think I'll take this one first because I think that they're two very different cases. Depo-Provera and the authorized generics is a unique case, and I'll let Tracy speak to that. What we're dealing with in GLP-1 are compounders, and those compounders are not part of the MDL, and the litigation is not directed at them. And there's some good reasons for that, including number one, we don't actually know what's in any of the compounds. There's some interesting laws in the United States that during times of shortages, people can make and sell compounded version of drugs. But there's a big difference between that and being an authorized generic manufacturer. The more important point is that I think these telehealth providers, a lot of them actually do sell the name brand drugs, and some of them there's a financial component, financial relationship with some of these companies. So, for example, Noom received some of its early funding from Novo Nordisk, the owner of Ozempic, and so the relationship between these these internet retailers is very much going to be a part of the marketing story of these cases, in how um, these companies are doing things that traditional pharmacies and drug companies cannot do themselves, making claims that go beyond the warning labels and the FDA approvals. And I think that will the relationships between these companies will very much be front and center as we get into the next phase in the litigation. But there's no direct liability as of right now.
You touched on in your presentation that you've been limited in discovery on the marketing issues. Does that complicate those cases involving those relationships between the pharmaceutical companies and these compounding pharmacies?
Not really at this point. I mean, we have sent out subpoenas to the vast majority of the third party um, telehealth providers, so that they're under notice to preserve documents. And I think we fully intend to go back at them as soon as discovery reopens on those areas. And so right now, we're focused on these narrow issues, which, as I indicated before, I have full confidence that we'll be able to more than meet the evidentiary standards, but resoundingly put to bed any of these lingering arguments after we get to put forward our case.
So just to chime in on the whole issue with generics, for the Depo Provera case, there was a stipulation that was recently entered to dismiss the authorized generics from the MDL. And I don't want people to get alarmed about that. What we have found is that the authorized generics had no control over the label. They were essentially distributors. So what they did was Pfizer contracted with them. They manufactured the product, and then they distributed it through these authorized generics. But it was actually Pfizer product under Pfizer's NDA. And we believe that Pfizer ultimately will be liable for the authorized generic use in this case, although we anticipate that it will need to be litigated at some point in time.
One other question that occurs to me, and I don't know that we discussed this in our preparation for this, but I'll throw it out there anyway. Alternative causation. Are there alternative causes for these injuries that we're seeing? The meningioma, I'm sure there are other things that give rise to meningiomas, but in the case of GLP-1s, the signature injuries here, the gastroparesis, what else might cause those, and how do you approach that when it comes to litigating a particular case and overcome those defense arguments that may be raised?
You know, it's funny. I'm dealing in another case right now with pretrial motions and dealing with this very issue. And one person's alternative causes are my baseline risks and thin skull plaintiffs, right? I mean, it's sort of all in the eye of the beholder. And in my opinion, yeah, gastroparesis and a lot of these conditions are tied to diabetes, but the reality is that that in these cases there's a time component along with the general causation component, and when by and large the mechanisms line up such that there really isn't much alternative causation if you believe that these plaintiffs have the they are not contraindicated, right? So if you think about the gastroparesis cases, those are the cleanest in terms of a sequence of time. Usually it's when someone is beginning to titrate up their dose or changing their dose, and there's a direct correlation to the onset of symptoms. Bowel injuries can happen a little bit later down the line, but again, what you see is it's a motility issue with the bowel or the intestine, in the same way that the stomach motility is impacted. When it comes to the eye injuries, again, there's obviously diabetics are at a greater background risk, but when you add to that greater background risk by multiplying it 2 or 3 or 4 or 5-fold, which is what some of these studies show, the evidence becomes really compelling. And so you take your plaintiff as you find them. And my view of the world is that these people who are at greater baseline risks in the first instance really require a better label. And those cases, in some ways, they're the people who need it the most. It's not a small risk if you're already prone to something. I've got a client who actually was diagnosed with NAION. He knew at the outset of his when he was starting to take GLP-1s that he was at risk for NAION. And so what did he do? He went to the doctor beforehand and asked if there was any correlation. He went to the actual pharmacy and asked if there was any correlation with NAION. And everybody said, no, there's no indication. These drugs are safe for people with smaller passageways where the nerves go in the back of the eye. And so he then made that decision to go forward and take the drug. To me, that is a very strong case because this is someone who was hypervigilant, even though they were at risk. And so I think really the key for these cases is pointing out, people take drugs, particularly pharmaceuticals for for type 2 diabetes and for weight loss because they have health conditions. And so these are the people who are getting these side effects. And of course they are, because that's who is intended to take them. So that's got to be part of our case.
Yeah.
Tracy, is that a significant consideration in the Depo-Provera cases as well?
So for Depo-Provera, meningiomas just generally are a very rare type of tumor, just in the general population. They're very rare. So there are some other alternative causes, but given how rare they are in the general population, and I agree with Jonathan, it's going to be the same type of issue, the thin skull plaintiff, what type of risk they were, how long they were on Depo-Provera is going to play into it, because there is definitely a dose response in the studies that are out there that the longer you're using it, the more likely you are to develop a meningioma. So there are some alternative causes, but overall, putting aside Depo-Provera use, the risk of developing a meningioma is very, very rare.
I know we want to leave time for some discussion here around issues of ethics in this type of mass tort. So I want to jump right to a question around that. Are there particular ethical concerns that, given the number of cases that are involved here, that that give you concerns that you have to be taken to very careful consideration when you're approaching these cases, whether they be around advertising, seeking out claimants who may be suffering from these injuries, or disclosures in client communications, or conflicts of interest? What's the biggest ethical challenge you see in these respective MDLs?
You want to go first, Jonathan?
Sure. I'll take that one.
Sure.
So I'll tell you all of the above, right? When we enter any mass tort, it's a minefield of legal and ethical issues. And the best thing that you can do is always talk to someone who's experienced before you get involved, because in every case that I've worked on, the issue of an individual hiring multiple lawyers has taken place. The issue of any issue that you can imagine does come up. I mean, I think that the most important lesson that I've learned in 22 or 23 years of mass tort work is that the most important thing you can do is communicate with your clients on an ongoing basis, and that the vast majority of complaints that go to the bars of the various states are because lawyers don't pick up the phone and call their clients when an issue is first brewing, because 99% of the time communication can solve those problems. And so I think that is the single most important thing. But I think as part of regular communication, sending regular letters to your clients, doing little things like even letting your clients know that you filed their case, I think is important. And being open with your clients about what the expectations are for their case, the timeline, and for them not to create unreasonable expectations as to what the value of a litigation is. Beyond those sort of basic things, we really try hard to vet our cases on the front end by making sure we've got medical records before we file cases, unless there seems to be some sort of urgent exigency. So a case comes in with a very reputable individual who believes that there's good reason to believe an SOL is impending. And I don't really love taking those cases. You've got to be a very special individual that gives me some heightened indicia of reliability. But I think generally speaking, all of these issues are significant. And then ultimately, right at the end of the day, to settle is each client's own individual decision. And so how you manage communication around resolution, how you manage allocations is really important, and how you communicate with your clients so that you don't favor one group of clients over another. All of these things are important, and you've got to be at the top of your game all of the time, because mass torts, implicit with mass torts is a lot of people, and the more people you represent, the better you've got to be, because 99.99% means you're still messing up 1 in 1,000 cases, right? You can't do 99.99%. You've got to do as close to 100% as possible. This is not something that anyone I know that's been in this business for a long time leaves to chance. Processes and procedures are the way to go.
I couldn't agree more. I mean, the two things I would really emphasize, which you've already touched on, is client communication and managing expectations right from the outset. And those two things go hand in hand. So if you're regularly in touch with your clients, you're regularly reporting to them, the obstacles and challenges and issues with the litigation, and keeping them apprised, you really manage expectations in the long run for those clients. And then the second thing is, and I'm a huge proponent of this, is to vet cases. Vet your cases up front. These are not, especially when it comes to the Depo Provera cases, they are not cases to just kind of warehouse and hold on to and file haphazardly without doing your due diligence and vetting these cases. You're not doing your client any favors by doing that. And at the end of the day, it just makes it much harder, much harder to reach a resolution for cases that are out there on file. So those are the two, real takeaways that I would suggest.
To paraphrase another common saying, it's communicate early, often, openly. It's 9/10 of the cure here.
Mm-hmm.
And the clients appreciate it so much. They really do. They might not always like what you have to say, but they appreciate it.
Exactly.
Yeah.
But in my experience, even delivering news to a client that they don't want to hear, still, if you communicate that in the right way, that they get the sense that their story's been heard and they've been given fair access to justice. And that's really what the civil justice system is all about, is that access to have your story told and heard.
100%.
Absolutely.
I know we want to leave time for questions from the audience, so I'd ask Allison if we have any questions that anyone has put into the chat that they'd like us to address.
I just had one question come in. I think this is probably for Jonathan. Is Victoza part of the MDL?
I believe it is. Yes. I should know that, but there are not a lot of cases from the early liraglutide type GLP-1. So liraglutide is the oldest of the GLP-1s. It and Saxenda, I believe, are definitely part of the MDL.
Thanks. Yeah. So if anybody else has any questions, put them in the chat and we'll continue to address them. Mark, I know you have some more up your sleeve too, so you can keep running through those.
I know we only have 5 minutes left, but I'll throw one out there. Obviously, the defense has their own strategy. So what do you anticipate, and are there any commonalities between these two MDLs in terms of the major defenses that the defendants are going to throw up in these cases, whether it be federal preemption, general causation? What's the defense that keeps you awake at night?
I think every MDL, not just these two, face the same challenges by the defense, and that's preemption and general causation. You know, it's universal across every MDL these days. Those two issues have been used as a weapon by the defense to try to, you know, reach a definitive, you know, motion for summary judgment early on, and knock the entire case out. And I think that's something that we see in every MDL these days.
You know, and it's fascinating. I totally agree with that. And what's fascinating to me is the defendants who are in possession of all of the information on day one that they need to move for a summary judgment motion for preemption, right? And it's entirely their burden. It's an affirmative defense. I've never seen a court say to a defendant, well, you want me to bifurcate, you want me to do preemption first, well, then file your motion tomorrow and show us all the evidence that you have, and then let plaintiffs do discovery in response to it. If you think you have what it takes to prove summary judgment, that there is no issue of material fact, show us the FDA communication, show us all of the underlying things that you have that result in the summary judgment. And it's really unclear to me why we as the plaintiffs bar don't get that opportunity, why we are always doing discovery in these cases, in these big MDLs, without a motion pending before us, where we know that the issue is something to do with preemption. But the defendants who are going to be filing that motion, who claim that there's no issue of material fact on their side, they don't put up the goods on the front end. To me, the analysis should be like, and it used to be 56F. I don't know what it is now, but it used to be, you know, when a defendant files motion for summary judgment, the respondent can say, well, I need time to do discovery and get affidavits together. So that was your response. And then the court would allow you leave. I don't understand why that's not the process in modern day MDL practice. If we're supposed to truly have no ambushes and openness in the court system, the court should be able to take a look on its face whether or not these defendants actually do have a preemption claim or not. And most of the time, given what the case law says, that it needs to be official agency action, they don't. There's no issue of official agency action. There's no indicia of official agency action. Defendants haven't moved the FDA or even sought from FDA permission for the type of label that would be at issue or would be contradictory to any state law. So that's the end of the analysis, right? So they haven't met their share, and I think we as plaintiffs need to be more aggressive in getting the defendants to issue frame this stuff on the front end. So this is my biggest lesson learned, quite frankly, is the next time I show up in a new MDL and defendants start saying preemption, I'm going to say to the court, we're fine with dealing with that early. However, they've got to file it and play their cards first. We'll do discovery after that. Because you waste so much time trying to figure out who the custodians are, who are the people that have the information, when theoretically the defendant should have all of this material all lined up before they even say, Judge, we want this bifurcated for preemption. So that's my soapbox.
That's an interesting strategy. I like
And
it.
we've taken it right up to the final minute. I want to thank you both, Tracy and Jonathan, for taking part in this. I think this was a very interesting conversation. And I want to thank Allison and Parent Conferences one last time for giving us the opportunity to speak to all the attendees today. Allison, anything more to wrap up here?
Yeah, I'll just again say thank you all for joining us. Thank you to Verus and Mark for sponsoring this webinar, and Mark, Tracy, and Jonathan for such an engaging discussion. Everyone can look for an email later today with the presentation materials and a link to apply for CLE. The 3 CLE code words were injuries, proof, and products. That's all from my end. Have a great afternoon.
Thank you, everyone, so much.
Thank you so much for having us.